warm welcome to the viewers of Legal Talks. Today, Advocate Dr. M. Sathya Kumar is with us. Welcome, sir.
Good evening, Ram.
Can you please elaborate on the powers of arrest under the Goods and Services Tax Act?
Ram, if you see, the Goods and Service Tax came into effect from 1st July 2017. One of the important powers under the Goods and Service Tax is the power to arrest, which is provided under Section 69 of the GST Act. It is the same section under the CGST as well as SGST, and the scheme of act is the same, whether it is CGST or SGST. Now, if you go through the provisions of Section 69, under Section 69 there is one subsection, subsection 1, wherein it states, where the commissioner has reason to believe that a person has committed any offence specified in clause A or clause B or clause C or clause D of subsection 1 of section 132. While you read section 169 of the GST Act, that is SGST or CGST as the case may be, the reference is provided to section 132. So, if the commissioner has a reason to believe, the word reason to believe is a very important phrase under section 69, because reason to believe is about the commissioner having the reason to believe. The jurisprudence of reason to believe have evolved over a period of time. Even under the Income Tax Act, there is a reason to believe in many of the act. That means reason to believe is the power of commissioner to determine the reason to believe. But that reason to believe has to be for what offences is the question. Those offences are listed under section 132, clause A, clause B, clause C, clause D of subsection 1 of section 132. Wrong. And then it says those offences under section 132 for which there is a power to arrest is punishable under clause 1 or clause 2 of subsection 1 of or subsection 2 of the said section. So, whatever is the punishment, the nature of punishment is also provided under section 132 as part of subsection 2. So, he may by order in this case of offences, that is section 132 subsection 1 clause A, clause B, clause C, clause D, in these case of offences, the commissioner by order authorized any officer, wording here is any officer of central tax to arrest such person who has done that offence. If you go through the subsection 2 of section 69 from the Bar Act of GST, section 69 subsection 2, where a person is arrested under subsection 1 for an offence specified under subsection 5 of section 132. So, there is a specific reference to an offence under the GST under section subsection 5 of section 132. So, under section 132, there is a subsection, that offence, the officer authorized to arrest the person shall inform such person of the grounds of arrest and produce him before a magistrate within 24 hours. If you see, section 69 subsection 2 is brought out the time limit of 24 hours, information of grounds of arrest. These are all required as per Constitution of India. Constitution of India provides a clear mandate with respect to power to arrest. What are the procedure to be carried out? Any law which contradicts the Constitution of India under Article 21 of the Constitution of India, Article 22 of the Constitution of India, especially with respect to arrest, will become unconstitutional. So, the test of constitutional validity of section 62 subsection 2, if you see, informing the grounds of arrest and taking the offender to the magistrate within 24 hours. So, if you go to section 69, subsection 3, it clearly says subject to the provisions of Code of Criminal Procedure 1973, where a person is arrested under subsection 1 for any offence specified in subsection 4 of section 132, shall be admitted to bail or in default of bail forwarded to the custody of the magistrate. So there are from this subsection, we can very well know there are two types of offences. One is a bailable offence, other is non-bailable offence. In case if he is arrested and brought to the magistrate, the bail can be provided. That is a bailable offence. And if the bail is not provided, he may be forwarded to the custody of the magistrate. That is judicial custody. Then comes, in case of a non-cognizable offence and bailable offence, the deputy commissioner or the assistant commissioner, for the purpose of releasing an arrested person on bail or otherwise, have the same powers subject to the same provision as an officer in charge of a police station. So in case of a non-cognizable offence, in case of a bailable offence, non-cognizable and bailable offence,
they both go hand in hand.
They both go hand in hand. So non-cognizable and bailable offence, in those offences, the deputy commissioner or the assistant commissioner shall have the power to act like a police officer with respect to providing bails and all those things. It's like an in charge of a police station. This wording is very important. If you see an act like Prevention of Money Laundering Act, the Enforcement Directorate is not recognized as a police officer. That means here when they say the assistant commissioner and deputy commissioner is recognized as a police officer in charge of a police station, what we need to understand and decode is that Code of Criminal Procedure 1973 CRPC with provisions which are applicable to a police officer will also will be applicable to the deputy commissioner, assistant commissioner with respect to non-cognizable offence and bailable offence. These are some of the important ingredients of section 69. So we are clear now that under section 69 there is a power for the GST department to prosecute and arrest. However, to understand this section 69, it is very important to understand section 132 because section 132 contains the ingredients of offence, the nature of offence. So here punishment for certain offences is section 132. It says section 132 subsection 1, whoever commits or causes to commit and retain the benefits arising out of any of the following offences, namely A, supplies any goods or services or both without issue of any invoice. If the goods and services are issued without the invoice, in violation of the provisions of this act, because invoice issuing is a mandate under the GST. Only when invoice is issued, we know the GST component of sharing of revenue with the CGST or SGST or IGST as the case may be. The rules made thereunder with the intention to evade tax. The intention of not issuing invoice is to evade tax. So that should also be believed by the commissioner. Then comes section 132 subsection 1 clause B. Issues any invoice or bill without supply of goods or services or both in violation of the provisions of this act. See, behind every invoice there has to be a good or a service. Goods or services. If both are not transferred or sold or supplied, in that situation, if the invoice is issued, fake bills, then it is ideally what purpose most of the suppliers issue fake bills for the purpose of claiming input tax credit. If that offence is also covered under the Goods and Service Tax Act under section 132 subsection 1 clause B. Then comes clause C, Ram. If you see, anyone who avails input tax credit using invoice or bill referred to in clause B, what we discussed now, fake invoice bill.
Like a bill trading.
Bill trading, BT companies. We all have seen many cases in the recent past across the country where bill trading companies or bill trading enterprises issue fake bills so that people use that bill for the purpose of claiming input tax credit and further take refund from the government. So in that case, if the fake invoice bill is used and any input tax credit is availed, that is also an offence. Without any invoice or a bill, that is also an offence because there is no underlying goods or services. Then comes clause D under section 132 subsection 1, where anyone collects any amount as tax. Somebody collects tax, but fails to pay the same to the government, fails to pay to the government beyond a period of 3 months, beyond a period of 3 months, there is a 3-month period for paying tax by filing the return. Beyond 3 months period from the date on which such payment becomes due. If the GST payment becomes due from the time when you raise the invoice or you rendered the services or sold the goods. In any of these cases, if you have not remitted the GST to the government at the earliest as per the due date, then within 3 months if you have not remitted at all, then it becomes an offence. And that offence is also covered under clause D of section 132. Then comes the clause E, where it says evades tax or fraudulent obtains refund, where such offence is not covered under clause A to D. So fraudulent refund. Then comes falsifies or substitute financial records or produces fake accounts or documents or furnishes any false information with an intention to evade payment of tax under this act. So all these clauses from E to L, further E to L deals with evasion of taxes in different modes. There comes what is the punishment. Section 132 itself provides for punishment. These are the offences which are listed here. What if somebody commits this offence? What is the punishment that is provided under section 132? For which the answer lies in clause I, wherein they say in cases where the amount of tax evaded or the amount of input tax wrongly availed or utilized, availed or utilized, or the amount of refund wrongly taken exceeds 500 lakh rupees, that is 5 crores, with imprisonment for a term which may extend to 5 years and with fine. So, in case of 5 crores, the punishment, imprisonment may extend to 5 years or with fine. And with fine. So, 5 years is the imprisonment for offences involving more than 5 crores. Then comes along with the fine. So, the imprisonment and fine both go hand in hand in GST. Then comes in cases where the amount of tax evaded or the amount of input tax credit availed, amount of tax evaded which the vendor has collected or from the customer, if he has not paid to the government, that is amount of tax collected and which is evaded, or the amount of input tax credit wrongly availed or utilized, or the amount of refund wrongly taken exceeds 200 lakh crores, 200 lakh rupees, that is about 2 crores, with imprisonment for a term which may extend to 3 years and with fine. Then comes in case of any other offence where the amount of tax evaded or the amount of input tax wrongly availed or utilized or the amount of refund wrongly taken exceeds 100 lakh rupees but does not exceed 200 lakh rupees, meaning 1 crore to 2 crores with imprisonment for a term which may extend to 1 year and with fine. In case where he commits or obeys the commission of an offence specified in clause F or G or J, he shall be punished with imprisonment for a term which may extend to 6 months or with fine or with both. So this is the scheme of section 132, Ram. We now saw section 69 and section 132. These are some of the provisions with respect to powers to arrest and the offences for which he can be a person can be arrested. This power to arrest solely lies with the power of the commissioner, because ultimately commissioner should have reason to believe. So reason to believe is about having a belief with certain evidences, certain information. The commissioner can have the
reason to believe,
power to arrest exercised on any person who has committed an offence under section 132 from clause A to clause D. And there are punishment provisions also provided, wherein maximum punishment you can see is 5 years and then 6 months is the minimum punishment depending upon the offence and the nature of offence.
The amount evaded
involved. So this is about the power of arrest and punishment under GST for the offences as provided under section 132 now.
So we discussed about section 132 and 69 of the GST Act. Can you please provide about the constitutional validity of the same sections?
This is an excellent question, Ram, because always when we look at these provisions as part of the any law, we deem to believe all these provisions are constitutional.
Constitution, yes.
See, even when I was actually talking about section 69, I was mentioning about a point where under the power of arrest, the procedure for arrest has been constitutional. But the question here is, section 69 itself is constitutional or not? Is a question that we need to understand by checking the constitutional validity. Ram, if you see, the embarking of the GST journey started with amending the Constitution of India. We know for amending the Constitution of India, we need 2/3 of Lok Sabha, 2/3 of Rajya Sabha, 50% of the state assemblies has to approve. And for what purpose? It is for the purpose of bringing Article 246A of the Constitution of India. Ram, Article 246A of the Constitution of India is a very, very important amendment under the Constitution. After Article 246 of the Constitution of India, the following article shall be inserted, namely, I quote, Article 246A of the Constitution of India, special provision with respect to goods and service tax. Under that clause 1, notwithstanding anything contained in Article 246 and 254, Parliament and subject to clause 2, the legislative of every state have the power to make laws with respect to goods and service tax imposed by the Union and by such state. Clause 2 provides, Parliament has exclusive power to make laws with respect to goods and services tax where the supply of goods or services or both takes place in the course of interstate trade or commerce. And there is also an explanation paragraph which clearly says the provision of this article shall in respect of goods and service tax. Tarun Basi versus State of Punjab and others. This is pending for hearing. It's very important to draw the attention to this case. Checking the validity of power to arrest under section 69 of the GST Act, CGST Act, or as the case may be, SGST Act, section 132 of the GST Act, wherein the challenge is based on the contention that section 69, that is the arrest, power to arrest, section 132, which makes certain acts, offences and prescribes a maximum punishment of 5 years, or criminal, or pertaining to criminal law, and thus could not have been enacted. This particular provision, if you see Article 246A and read through the article, the ingredients of the article is very simple. The Parliament and subject to clause 2, the legislative of every state have the power to make laws with respect to goods and service tax. It's not about the criminality of the goods and service tax. It is the power brought to levy tax.
Levy and collect taxes.
Collect taxes, but it does not go beyond that. It does not talk about the criminality. If you are talking about the criminality and enacting a criminal law, then the route available for the legislative is organ of the legislative. Organ of the constitution is one of the organs legislative. Is entry 93 of list 1, which provides the field to make criminal laws with respect to matters in list 1 to Parliament, whereas entry 64 of list 2 provides similar field of enactment to the states. So entry 93 of list 1 provides for enacting a law for criminal law. Similarly, if you ask in the state list, entry 64 provides for the power to bring in criminal law. But Article 246A, which was brought as an amendment under the Constitution to only levy tax, cannot be the basis on which the criminal law can be brought in indirectly. 246A empowered the government, both the union government as well as state government, to bring in GST law. But it did not empower to bring criminality under the GST law itself. That is the contention under the petition of Tarun Basi versus State of Punjab and others. So, referred to in clause 5 of Article 279A take effect from the date recommended by the Goods and Service Tax Council. And then subsequently all other articles relating to this 246A got also amended. Like amendment of Article 248, amendment of Article 249, amendment of Article 250, amendment of Article 268, amendment of Article 268A, amendment of Article 269, amendment of Article 269A. So subsequent amendment also happened, giving effect to Article 246A of the Constitution of India. Ram, why am I discussing about 246A now? when we are discussing about the power of arrest and the offences under section 132 of the Goods and Service Tax, the reason is GST department is empowered to arrest persons accused of offences specified under section 132 of the CGST Act 2017 and proceed with arrest as per the procedure laid out under section 69 of the CGST Act, same act. In Punjab and Haryana High Court, there is a petition pending for hearing under the cause title C versus State of Punjab and others. This is pending for hearing. It's very important to draw the attention to this case. Checking the validity of power to arrest under section 69 of the GST Act, CGST Act, or as the case may be, SGST Act. Section 132 of the GST Act, wherein the challenge is based on the contention that section 69, that is the arrest, power to arrest, section 132, which makes certain acts, offences and prescribes a maximum punishment of 5 years, or criminal, or pertaining to criminal law, and thus could not have been enacted. This particular provision, if you see article 246A and read through the article, the ingredients of the article is very simple. The parliament and subject to clause 2, the legislative of every state have the power to make laws with respect to goods and service tax. It's not about the criminality of the goods and service tax. It is the power brought to levy tax.
Levy and collect taxes.
Collect taxes, but it does not go beyond that. It does not talk about the criminality. If you are talking about the criminality and enacting a criminal law, then the route available for the legislative is organ of the legislative. Organ of the constitution is one of the organs legislative. Is entry 93 of list 1, which provides the field to make criminal laws with respect to matters in list 1 to parliament, whereas entry 64 of list 2 provides similar field of enactment to the states. So entry 93 of list 1 provides for enacting a law for criminal law. Similarly, if you ask in the state list, entry 64 provides for the power to bring in criminal law. But article 246A, which was brought as an amendment under the constitution to only levy tax, cannot be the basis on which the criminal law can be brought in indirectly. 246A empowered the government, both the union government as well as state government, to bring in GST law. But it did not empower to bring criminality under the GST law itself. That is the contention under the petition of Tarun Basi versus state of Punjab and others. So the point to be here, a point to be noted here, but the power of arrest and the prescription of sentence was neither covered under ancillary nor incidental matters under entry 93 of list 1, neither entry 64 of list 2. It was just brought in as one of the section under the CGST Act. And the provision for arrest and sentence for an offence against the law could be inserted by any enactment if permitted by the constitution only. Here, say article 246A seem not to permit any other scope of legislation other than the power to levy tax and collect tax under the GST. So therefore, the power to arrest an offence amounting to enacting a criminal law, section 69 and 132 of the CGST Act, could not have been enacted under general power to levy tax as provided under article 246A of the Constitution of India, thus or beyond the legislative competence of the states and the centre. Accordingly, this will become unconstitutional. Is a submission made under Tarun Basi versus state of Punjab. But of course, different high courts have held different views in different cases. Let us see all those high court cases. As you may be aware, section 69 and section 132 is a scheme under the GST itself. The question is about the constitution, which we discussed right now. But different high courts should have examined whether it is constitutional or not. This is the case that is pending before Punjab and Haryana High Court, which is put for constitutional test because the High Court is a constitutional court. But different other High Courts have held different views. Ultimately, the matter will come up before the Apex Court and the constitutional bench would have to decide in future. But let us see what different views were held by different High Courts around the country. If you see, Ram, the Telangana High Court, in the case of P.V. Ramana Reddy versus Union of India, 2019-25 GSTL in 185, has upheld the commissioner power to order an arrest if a cognizable and non-bailable offence has been committed, and accordingly they have denied the pre-arrest bail. Whereas, if you see, there is a straight contrary view taken by Bombay High Court in the case of Sapna Jain, CWP number 1996/2019, said that no coercive action, very important, no coercive action should be taken against the taxpayer and no arrest should be made. That is a contrary view taken in Bombay High Court. So we saw Telangana High Court, we now saw Bombay High Court. Let us now see what is the Supreme Court stand with respect to arrest matters. Considering the confrontation, the Supreme Court in case of Pradeep Kaustubh Shukla, the Commissioner of GST and Central Excise, under a special leave petition 6834/2019, granted interim protection against coercive action subject to payment of 10% of the alleged GST evasion amount. Ideally, if you look at the Supreme Court, if you look at the decision, as said very clearly, if somebody is ready to pay for 10% and move for the appeal, coercive action of arrest should not be taken. Recently in Punjab and Haryana High Court, in the case of Akhil Krishna Magu and others, CWP number 24195/2019, has observed that taxpayers against whom no concrete evidences are available, to establish evasion of tax should not be arrested before the determination of liability and imposition of penalty. First of all, before freezing what is the tax amount that has been evaded and penalty amount that is being levied, he should not be arrested. Further, the Punjab and Haryana High Court gave a clear observation saying it is also stated that arrest of chartered accountants, because it's become routine matter now to arrest chartered accountants, because if there is any evasion of GST, immediately chartered account is linked and he is arrested. In this case of routine arrest, there is an observation of the Punjab and Haryana High Court which clearly said that chartered account advocates should not be carried out, arrest of a chartered accountant and advocate should not be carried out in the absence of corroborative evidence linking them with the alleged offence. Therefore, to be intact in Article 22 of the Constitution of India, which provides for the fundamental rights of every arrested person, any coercive action by the GST authorities against the constitutional mandate would lead to power of arrest under section 69 and 132 unconstitutional. So, they will be eligible for bail even if they are arrested, if they are not following the procedures as laid down in the Punjab and Haryana High Court. Finally, in case of Poolpandi versus Superintendent of Central Excise, AR 1992 Supreme Court judgment, that is in Central Excise matter, held that there being no prohibition under the Act to deny him the assistance of a lawyer, such a right would be violative of Article 20 Clause 3 of the Constitution, and that in view of the constitutional protection of life and liberty, personal liberty, guaranteed by the person concerned is entitled to a lawyer during questioning by the department. As the law doesn't restrict the lawyers to come and assist, he has to be provided that access, is what the Poolpandi versus Superintendent Central Excise, the Supreme Court judgment has held. Applying the just, fair and reasonable test, it cannot be said that calling a person away from his home and questioning him in the atmosphere of the customs office without the assistance of this lawyer or his friends either violates his constitutional right under Article 21